Hello, everyone. Thank you for joining us today. We will start in a few minutes, just waiting for everyone to shuffle in. Thank you. Enjoy.
Ladies and gentlemen, welcome. On behalf of my colleagues and myself, let me start with wishing you a very good new year 2021. Health and joie de vivre, I would say, are certainly to be put on the agenda for 2021. Welcome also to our first webinar in a series of webinars for 2021. As the ones who have already been attending our webinars know that you can ask questions. You can put them in a special dedicated frame on the right corner of your screen. You can type them and we will have the pleasure at the end of our intervention to answer them. As the coronavirus continues to disrupt the economic activity in Belgium and broader in the EU, the world, businesses are today reviewing their corporate structures to deal with the crisis. That's why today we will, with you, dig into the different scenarios of restructuring and main items where companies might expect an impact from, as well as discuss a practical approach of collective dismissal to end with quite a variety of possibilities to avoid the worst case scenario, that is a dismissal. Your panel today is composed of Anne Camp, Tim Perdieux, and myself. And the first question we are deemed to ask ourselves is obviously, why are companies reorganizing? Why are they restructuring their activities? In the current difficult business environment, a company might consider different reasons. It might consider undertaking a corporate restructuring as a mechanism to ensure business continuity. That means that they want to have the same number of employees being employed, the same level of activity, the same turnover. But also, some companies might do it just to survive beyond COVID-19. That's why companies will probably try to improve their overall business efficiency, or even some companies position themselves as an attractive candidate for investment, merger, or even as a target for acquisition. Without being exhaustive, we have put together a table on the next slide, a number of scenarios identifying the restructuring from a socio-legal perspective. As I said, this table is not exhaustive, but it gives you an impression of a number of scenarios which you might find yourself or companies might find themselves into. The individual dismissal, still, of course, we see in our daily practice quite a number of companies who perpetrate an individual dismissal. Interesting to note that because of COVID-19, well, still an individual dismissal will have to be motivated if employees ask for it, and the normal severance pay, which is determined by law, will have to be complied with, will have to be paid, or notice period to be served. So no changes in that perspective. A multiple dismissal of multiple employees, as the word says itself, but not a collective dismissal. The number of dismissal does not reach the thresholds of a collective dismissal. It's mainly regulated on a sector level, so by collective bargaining agreement. So whenever you have more than one, I should say, dismissal in a very short period of time, you should have a look at the collective bargaining agreement in the sector of industry, whether that collective bargaining agreement or that sector addresses a multiple dismissal. It's mainly focusing, or the collective bargaining agreement will mainly focusing, in most sectors this is the case, on information, on hearing, not necessarily on an extra allowance to be given. The collective dismissal, I'm not going to go into detail, too much detail, because Anne is going to elaborate on that subject. But interesting to know that there is no one definition of collective dismissal. It is a number of employees being dismissed in a 60-day period, and reaching a threshold, a particular threshold. Interesting to notice also here that there will be no immediate termination, but that first a lengthy procedure of information consultation will have to be run through before the employer will be able to notify the dismissal and to terminate the employment contract. So interesting topic here in this respect. A transfer of company, conventional transfer of a division or of a company. It can also be one of the, I would say, issues or solutions for a company to survive or to enhance the efficiency within the company. It's not about dismissal, certainly not because of a transfer, because the collective bargaining agreement 32bis explicitly prohibits employees to be dismissed because of the transfer. Nevertheless, dismissal can occur for other reasons, but it needs to be duly motivated. Representation or employee representation will also come into play in respect of information consultation of the employees. Judicial reorganization is a specific format of reorganization of a company. It's the aim to maintain the company and the continuity of the activity within the company or part of it, but under the control of a judge. This can be done in different ways. The aim is to reduce or to restructure the debt This can be done by common consent. It can be done by an agreement with the creditor on a reorganization plan, or it can be done by transfer of a part of a company or a company. There again, no dismissal necessarily will be the outcome. It can be. Motivation, obligation applies still when the employee asks for it. Interesting to notice here is that the implication of the employee representatives consultation information will be limited. It will be mainly about hearing and about the consequences, giving information to the outcome of the judicial reorganization to the employee representatives. And then last, the closure of a company where the main activity is stopped or it occupies less than 25% of the employees it occupied the previous year. Then we talk about a closure of company or closure of a division whenever the division is sufficiently independent from the other activities, from the other departments. Closure of company, again, dismissal, motivation, etc. So we are in this table, we give you an overview of the major impact of different scenarios. Of course, not exhaustive, not complete, I would say, and also to be nuanced, because a yes and a no is white or black, but it needs to be nuanced, some details. But of course, it would lead us too far to go into detail for every scenario. It gives you an overview of the possibilities. Also, some of those scenarios can be combined. For instance, there can be a combination of a closure of company, legislation to follow, together with a multiple dismissal regulations put forward by a collective bargaining agreement in a sector to follow. So both can, in some cases, or need to be followed, need to both procedures. As many forms of corporate restructuring generally come with a financial cost, the various COVID-19 related financial support schemes being offered by the Belgian government should also be considered as means of funding the implementation of a corporate restructuring plan and indeed to reduce costs. And that is what those special COVID initiatives by the government aim to. All of these measures have three elements in common. They only apply whenever the company has been recognized as a company in difficulties or restructuring. They have both a very specific legal definition. If we are talking about a company in difficulties, we are talking about a company which is indeed underperforming compared to previous years in respect of turnover, in respect of financials. A company in restructuring is a company which already undergoes a collective dismissal. And other criteria, conditions apply. So whenever they have been recognized before the 31st of December 2020, three options are possible for the companies. That is, the collective working time reduction, corona time credit, senior time credit, or the landingsbaan créditant for fin de carrière. Now, I said that there are three things in common. First of all, there need to be for companies only which have been recognized before the 31st of December 2020 as company in difficulties or in restructuring. Second, all of these measures are with the agreement of the employee or workers' representatives. And third is that all these measures are temporary for the company. What is the collective work time reduction? Well, a reduction by 20% or 50% of the working time during 1 year, together with a social security reduction. Corona time credit is a temporary time credit, which is a separate time credit, so it doesn't impact on the normal credit time credit legislation or possibilities and entitlements. It's a temporary reduction of 20% or 50% of the activities between minimum 1 month and maximum 6 months, and a contract of a part-time activity needs to be concluded. The senior time credit, landingsbaan créditant fin de carrière, is to reduce the activity by 20 or 50%, but then for every person as from the age of 55, which is lower than the normal age for those end of career time credit. So certainly also to mention that this is to be taken advantage of. A few other topics just to contemplate is that, and when you read HR newsletters, quite some companies are thinking about a voluntary leave policy to be put in place. Obviously, they will not count as dismissal. They will not be considered as a dismissal. And it can be indeed a solution for people who are already intending to leave. And instead of paying the normal dismissal payment, severance pay, it can be considered to give or to grant a special premium, which is lower. Needless to say that, of course, this might have an impact for the employee, him or herself, on the unemployment benefits. But a resignation or a termination by common agreement could also certainly be a solution for companies. Whenever a change of employment conditions occurs, and Tim is going to go way more in detail, but whenever this is this concerns a essential element of the employment contract, and it is a substantial change, well, then it might be considered as a constructive dismissal, and that in its way, in its turn, may be considered as a dismissal to be taken into account for the thresholds, for instance, of collective dismissal. So also mind that is important. And for those companies who might have thought that COVID-19 would be considered as a force majeure or overmacht, well, because it is temporary, this is not considered as overmacht, force majeure, act of God. And as such, a termination pay will have to be paid, which is indeed for an act of God, or if an act of God can be invoked, not necessary. And then to introduce Anne, and we are lucky because no sooner than this morning around 10 a.m., the Federal Service Employment published its latest figures on collective dismissal. You will find that on the website of the Federal Service Employment. I'm not going to go into detail, but it gives you an overview of different items in respect of collective dismissal and statistics in respect of collective dismissal. But to summarize and to give you a few figures, in the period January-September, there were 3,349 announcements, or to be more precise and to be correct, there were 3,349 employees impacted by an announcement of collective dismissal. In the period September to December, 3,617 employees were impacted by an announcement of collective dismissal. That means that in the period between September and December, well, October, December to be precise, there were more employees impacted by an announcement of a collective dismissal than the 9 previous months, October, December. Nevertheless, the Renault Act and the Information and Consultation Procedure seems to be working in that sense that in that period, in the whole period of 2020, about 760 jobs were saved because of a successful information and consultation procedure, meaning that during that procedure, other means were searched to avoid dismissals, and that was successful for 760 jobs. So with that, I leave the floor to Anne, who is going to take us through in more detail through procedure and the aspects of collective dismissal, as we see quite important also to discuss today. Anne, the floor is yours.
Thank you, Stefan. Hello, everybody. So if after having considered alternatives to dismissals, it appears for you that there is really no other solution than to proceed to dismissal, you will have to check whether the contemplated restructuring must be considered as a collective dismissal. And today, from my part, I will remind you of the main principles of the collective dismissal procedure, and I will more particularly focus on the mandatory prior information and consultation obligation towards the employees' representatives. So which legislation provides for this information and consultation obligation? On the one hand, we have the collective labor agreement entered into at the federal level, collective labor agreement number 24, and we have also the well-known law of 13 February 1998, or the so-called Renault Act. So when must a company consider whether or not the contemplated restructuring is or not a collective dismissal? This applies for enterprises of more than 20 workers. So I draw your attention on the fact that my presentation of today is limited to the information and consultation procedure. You have also other applicable legislation with other thresholds. And so the purpose today is not to go into detail in all of this legislation, but only on the information and consultation procedure. So as soon as an employer has more than 20 workers, he must be careful, because we have a collective dismissal if in the same period of 60 days, and that period of 60 days is counted from day to day. So within the 60 days period, if the company performs a certain number of dismissals, the restructuring can be considered as a collective dismissal. What are those thresholds? At national level, federal level, so companies employing more than 20 employees but less than 100 employees, then we speak about a collective dismissal as soon as the employer has the intention to dismiss 10 or more employees. For companies who are employing more than 100 workers but less than 300 workers, there is a collective dismissal if within the same period of 60 days there is an intention to proceed to the dismissal of 10% or more of the staff. And for companies employing more than 300 workers, we have a collective dismissal as from 30 dismissal. As Stefan already pointed out, so the thresholds I just mentioned are the thresholds on federal level, but it is possible that at sector level there are collective labor agreements that provide for lower thresholds. If this is the case, then we speak about a multiple dismissal, and then you must also initiate the information and consultation procedure towards the employee's representative, then by application of the sector collective labor agreements. So my message today is, please always check also at sector level whether the contemplated restructuring must not be considered as a multiple dismissal, and check whether you have to comply with the prior information or consultation procedure. So which dismissals must be taken into account to verify whether you reach the threshold for collective dismissals? So it are only dismissals for economic reasons, so no dismissals that are only related to the performance or the competence of the employees, but only economic reasons. And in this respect, it is interesting to point out that if as a result of your restructuring, you have to terminate anticipatively a contract for a definite period, this termination must also be taken into account for the calculation of the thresholds. What is the reference period? The reference period is the average number of employees in the calendar year preceding the collective dismissal. So if you would contemplate a collective dismissal in this year 2021, then it will be based on the average number of employees in 2020, and the number of employees is calculated on the basis of the declaration to the National Social Security Office. And then an important topic is the question, yes, but at which level do I have to verify whether the thresholds are reached or not? Because we are speaking of an enterprise, what must be considered as an enterprise in the meaning of the collective dismissal legislation? So an enterprise is considered as the technical business unit, de technische bedrijfseenheid, l'unité technique d'exploitation. This is a notion we know from the social elections. And we know that a technical business unit can correspond to the legal entity, but also several legal entities can be considered as forming one technical business unit. And a third scenario could be that within one legal entity, you have several divisions that could each be considered as a separate technical business units. So the legislation, so the Renault Act provides expressly that for the application of the collective dismissal procedure, the enterprise is also a division of a company is also considered as an enterprise. And what is a division? In fact, there is no real legal definition of a division, but we must consider that it is an organized entity of persons and elements that allow to exercise an economic activity that is pursuing a proper objective. So a division must have some autonomy from a social and economic point of view. And so the thresholds for collective dismissal must be calculated on different levels. So on the level of the legal entity, on the level of the technical business unit, but also on the level of the division. So for example, if you have several legal entities that form one technical business unit, maybe at the level of the technical business unit, you will not reach a threshold, but if the threshold is nevertheless reached at the level of the legal entity, you have to start the prior information and consultation procedure. And then what is also very important to communicate is that the legislation and the collective dismissal and the prior information and consultation procedure is applicable as soon as the employer has the intention to proceed to a collective dismissal. So you have to initiate the information and consultation procedure before any definitive decision of collective dismissal has been taken. So this means that in every communication, you must be very cautious because sometimes it appears from emails between management members that they have in fact already the intention to proceed to a collective dismissal while they did not yet initiate the procedure. So as soon as employer you really contemplate a restructuring, be very careful in your communication. And so who has to be informed? The law says the employee's representative. So that is a works council if there exists a works council. If there is no works council, you have to inform the trade union delegation. If there is no trade union delegation, you have to inform the Committee for Prevention and Protection at Work. And if you do not have any representation body within your company, you will have to inform the workers individually. So in practice, when you don't have a representation body, what do the workers do? They appoint among themselves some representatives to go through the information and consultation phase in their name. And so there is only a little group of workers that are working with the management in the phase 1 of the consultation procedure. And so it's very important to have the reflex to initiate the information and consultation procedure as soon as it is required. Why? Because there are severe sanctions that are applicable. First, there are criminal sanctions of level 2 by application of the social criminal code. And those sanctions are multiplied by the number of employees involved with a maximum of 100. This means that, yes, the administrative or criminal fines can really be very high if the social inspection would consider that the violation is very serious. There are also civil sanctions. So if you have proceeded to dismissal without compliance with the information and consultation procedure, then there are different sanctions in function of the way you terminate the employment agreements. If you gave a notice period, then this notice period will be suspended until 60 days after the employer has notified the collective dismissal to the sub-regional employment office. Those 60 days correspond to the freezing period of 30 days, which I will explain you later on, and that can be extended to a maximum of 60 days. If you dismissed with the severance indemnity with immediate effect, what is the sanction then? The employees can ask for their reintegration. In that case, you as employer will have to pay them the loss of salary, and of course the employee will have to reimburse the severance indemnity. If you do not want to reintegrate the employee, then you will have to pay the employees the salary up to 60 days after the notification of the collective dismissal to the sub-regional employment office, this on top of the severance indemnity. And then here I have summarized really in a nutshell in one slide the overview for the information and consultation procedure and the collective dismissal procedure. I will go through it with you. So the first step at the left side of the slide is that, yes, of course, before deciding to opt for a collective dismissal, this must be the object of a decision of the board of directors. So once the board has decided to go for a collective dismissal, the procedure starts with written information towards the works council or the committee or the trade union delegation. That written information must be drafted by using a standard form that is provided by the Public Federal Service Employment. And so the written information must, among others, provide for the reasons of the redundancy, the number and categories of the workers that are affected, the period over which the redundancies will be carried out, and also the criteria that will be used for the selection of the employees to be dismissed. So the day after the day of the written information towards the Works Council, you must convene a first meeting of the Works Council. Normally at that meeting, you will plan in agreement with the employees representative a calendar for next meetings at the occasion of which you have to inform and consult the employees representatives regarding the possible solutions to avoid the collective dismissals. So you can never know in advance how long this phase one of the collective dismissal procedure will last, because it will depend on how many meetings you will have to have with the Works Council. And then at a certain moment, when the employees representatives are satisfied that they have been so duly consulted, then phase one, meaning the information and consultation phase, can be closed. And it is important to provide a specific minute of the Works Council for that, in which, together with the employees representative, it is confirmed that phase one was duly performed and finalized. After this last meeting of the Works Council, then the employer must notify the decision to go for a collective dismissal to the Regional Employment Office, to the Federal Public Service Employment, to the Works Council, and the decision must also be posted within the company. As from that date on, there is a freezing period of 30 days during which the employer may not proceed to any dismissals. At the request of the Regional Employment Office, the freezing period can be extended to a maximum of 60 days. So during this freezing period of 30 days, normally the management and the employees representative will finalize a social plan. The employer will create an employment cell, and the outplacement procedure will be put in place. What is an employment cell? For your information, it is kind of corporation structure, and with part of the employment cell, it is of course the employer under restructuring, but also at least one of the representative trade union organizations. Also, if it exists, the sectoral training fund is part of the employment cell, and it is operated under direction of the competent regional employment office. So all that is put in place, and at the end of the freezing period, then the employer must invite the employees to a meeting that can only take place at the earliest 7 days later. And at that meeting, each member of the personnel involved concerned by the collective dismissal will be informed of the existence of the employment cell and the outplacement offer. The employee has then 7 days to accept or not to participate to the employment cell, and after those 7 + 7 days, then the first dismissals can be performed. Then the employment cell will work, and so for employees of less than 45 years, so they have to collaborate and be part of the employment cell for the duration of their severance indemnity, but for a maximum of 3 months if they are less than 45, and for a maximum of 6 months if they are more than 45 years. So thank you for your attention, and now I will leave the floor to Tim, who will explain you which alternatives there exist to collective dismissal, which remains, of course, the worst case scenario. Thank you very much.
Thank you, Anne. Indeed, in this final part, we will look at a number of alternatives to restructure without dismissal. The first and self-evident measure probably to reduce salary cost is a salary freeze. no increase of salaries for a certain period of time for all employees or for an objective category of employees. In principle, employees do not have any right to a salary increase unless something has been specifically agreed, for example, in their employment contract or in the offer. As a result, this measure can be taken unilaterally by the employer without employee consent. Sector rules on indexation and minimum salary scales and other benefits, of course, have to be respected. This means that as a result of indexation, the costs, even in case of a salary freeze, still can increase. For example, in Joint Committee 200 in January this year, the indexation will still lead to a 0.95% increase of salaries. A less popular measure to reduce salary could be to reduce salary conventionally. This can also be used to neutralize an already acquired previous indexation. But as Stefan mentioned, as salary is an essential element of the employment contract, a salary reduction cannot be applied unilaterally. In case of a unilateral reduction, the employee can ask a court to reinstate the agreed salary, or even to rule that the employer is guilty of a breach of contract and has in fact immediately dismissed the employee. In that case, a severance payment is due, next to possible other claims, also, for example, manifestly unreasonable dismissal. An agreement is thus required and can take the form of a company-level collective bargaining agreement, collectively, or can be agreed individually in an annex to each employee's contract. Individual employees can, however, not be forced and must be given sufficient time and information to decide, otherwise their consent could be considered invalid. Though not popular, such agreements do exist, for example, where engagements are undertaken by the employer in terms of job security to maintain staff on board. Again, sector-level minimum conditions also have to be applied in this regard, with regard to the salary reduction. For bonus entitlements, it's best to plan ahead and set up your bonus plan in such a way that it maintains as much flexibility as possible to decide on payment or amount of the bonus. In that context, it's important that bonus entitlements are not gradually acquired as the reference period continues, but only at the end of the reference period or even after, as a whole or not at all. Appropriate wording in the bonus plan is, of course, key. A better way to reduce salary costs would be one where employees still get the same net amount on their bank account, but the cost for the employer is lower. In that context, you can look to many alternatives, but in this slide, we provide a comparative overview of some possibilities to optimize bonus payments. We start in the pink column at the left. We start from a gross cash bonus of 10,000 euros in the yellow cell. That amount cash bonus is subject to high normal employer and employee social security contributions and taxes. Vacation pay is also due on top of it. The employee takes home from those 10,000 euro gross 4,675 euros net, which costs the company 14,000 euros, a net over cost ratio of only 32%. In the other columns, we have made calculations to arrive at that same net for the employee, but we will see what the cost amounts to. In the blue column, we make use of the regime of the collective non-recurrent result-tied bonus, the CBA 90. This regime is very interesting as the bonus can be awarded free of tax, which leads to a net over cost ratio of over 65%. The amount is, however, capped at 3,447 euro gross per employee per calendar year for this year, which means that we still need to add on another element to reach our same net in this example. In the purple column, we have made a calculation based on the still relatively new regime of the profit premium, which is also a collective regime which applies for all employees if you implement it, but different amounts can be awarded based on selected objective criteria. This regime is also highly discretionary as it does not give any rise to future acquired rights from the employees. In this example, we can pay employees the same net for a cost of almost half of that of the cash bonus. In the green column, we address payment through warrants, which provide a much more possibility to go individually differentiate between employees. This regime does not provide for social security contributions, and as a result, we are able to reduce our cost with almost 4,000 euros compared to the cash bonus. In the last column, the orange one, the same calculation is made for payment of a bonus in a supplementary pension plan. With a net over cost ratio of 68%, we reduced employer costs with more than half, and this is clearly one of the most financially efficient ways. It's, however, a form of deferred compensation, as employees will have to wait in principle until they reach the applicable pensionable age to draw up the funds. A combination of these regimes, as well as others, can of course be considered. Also, you could consider introducing a cafeteria plan, for example. The current pandemic still has many of us working from home. Also, employees are still mandatory working at home in the context of COVID-19 telework, which was, by the way, extended this Tuesday until the 1st of March of this year. Beyond the pandemic, however, introducing structural telework can also be a very interesting way to motivate and engage employees, whilst also at the same time reducing office costs. If a sufficient level of employees would work from home, fewer office spaces are required, and also the employer is no longer required to intervene in commuting costs. These measures have been addressed in detail in our last webinar. If you are interested in how to implement this, we are happy to provide you with a recording on request. Reducing salary can also be done by avoiding having to pay unnecessary additional amounts and supplements, such as in event of overtime work. This can be done in different ways. For example, in the context of structural telework, working time limits do not apply, and employees are not entitled to any pay for overtime. The same is the case for certain personnel members in commercial, sales representatives, management, or trust positions, provided that this is properly provided in their contracts or in the work regulations. Another way to remove overtime altogether is to move to floating work schedules, which allow employees within fixed limits set by the employer to determine when they start and end their working day, with a maximum of 9 hours a day and 45 hours a week. Another possibility is to opt for flexible work regimes, where the employer can decide to increase or reduce effective weekly working time in function of increases and decreases in work volume. Such regimes must be formally introduced by the work regulations. As mentioned by Stefan, COVID-19 measures permitted certain companies to introduce temporary working time reduction, but there is also a general scheme. I will not go into detail to limit the time that we have, but the general scheme for working time reduction still applies, and you can reduce your working time in the company with 1 hour or move to a 4-day week even, and benefit from a reduction of social security contributions up to even 4 years for 400 to 1,000 euros per employee per trimester. Another manner to reduce working time, but then on individual basis, would be to agree with certain employees that they would move to a part-time work schedule and reduce their salary in that regard. Such change, however, requires written consent of the employees through an annex to the employment contract, and does not provide for any right to compensation through interruption allowances. A better way to come to the same result is to convince employees to take up entitlements to motivated time credits or parental leaves, some of which highlighted by Stefan. Different possibilities apply in that regard, ranging from a 1/10 parental leave time reduction to even full-time suspension for a certain period of time, whilst receiving an allowance from the employment office to compensate the corresponding loss of salary. Of course, conditions apply and use is limited in time per employee. During periods of decrease of work, employers can also ask their employees to take up vacation and other paid leave entitlements, or even unpaid leave. This, of course, also requires agreement of the employee. In the event of returning periods of decreased work, it can be considered to introduce periods of mandatory collective vacation or closure of the company. This has to be provided in the work regulations at the latest in December of the preceding year. An alternative for periods of lack of work, which does not require employee consent, are are temporary unemployment schemes, such as the currently commonly applied force majeure temporary unemployment due to COVID-19, you all know very well, and the specific simplified regime that still applies until the 31st of March this year, but can still be extended. Of course, beyond that, as we already discussed previously, you will still be able to make use, under the set conditions, of temporary unemployment for economic reasons if required. Sometimes one department or business location may be struggling to keep up with work, whereas other departments or locations are overstaffed. Moving employees from one function or location to another one is, however, not as straightforward as it may seem, as the function and workplace are generally also considered essential elements of the contract. In event of a unilateral change, the risk exists that an employee may again invoke a breach of contract, resulting to an implicit dismissal by the employer if that is an important change. Careful consideration of all facts in the contractual clauses is advised, and it's also very useful to plan ahead and include flexibility clauses in template contracts in general. Such clauses also have their limits, of course, and in many cases, individual consent will still be required to effect the change. Another alternative can be to work with temporary work and making smart use of regimes as interim work, fixed term contracts, or contracts for specific work, and avoid over-engaging permanent workers who later then would need to be dismissed. Important to note is that putting own employees at disposal of another company, even another group company, with a transfer to that company of an instruction right over the employee is prohibited by law. This also applies in the context of a secondment scenario, for example. Exceptions, however, apply and can be used, or a workaround can be provided, such as through a service agreement providing for a very specific and limited instruction right, such as by setting up an employer group, or by entering into a multi-employer employment contract with the employee, the so-called global employment contract. As the employee is not with you during that time, de facto, the headcount is reduced without dismissal. The same applies for full-time suspensions, of course. In the context of restructuring, a transfer of a part of the company can also be considered, as Stefan already indicated. In event of a TUPE transfer, employees follow the transferred activity to which they belong to the new employer while maintaining their rights, and they also benefit from a dismissal protection. Specific information and consultation duties, of course, apply in that scenario. To avoid dismissal of employees, next to making smart use of fixed-term contracts, you can also consider to first reduce, terminate working relations with self-employed contractors or consultants and interim workers, whilst, of course, still respecting contractual agreements. Lastly, as Stefan already mentioned, an employer can propose voluntary leave schemes. And, of course, all these elements discussed can be addressed in much more detail, as well as many other ones. And we are, of course, happy to answer any questions you may have in this regard. Thank you.
Thank you, Anne. Thank you, Tim. Well, we are indeed a little bit running over time. I don't see any questions, so it's time to wrap up this session. And as we already indicated, we have been giving you in 45 minutes an overview of possible scenarios where you might find yourself, your company, or just now in the future, etc. So to give an overview of possibilities, either to avoid dismissals, to optimize the efficiency, to optimize the cost within the company, and otherwise, whenever the worst is indeed to come in case of dismissal, even then to take advantage of the possibilities offered by law to think and to contemplate how to avoid the most possible the termination or the dismissals. And that is also what is shown in those figures of the Federal Service, that is that the information consultation procedure, this is in an organized form, but I think it can also be organized in a more informal way in a company, to think about end of career planning, to think about reducing the worker working time individually on an informal way together with the employee to reach an agreement, and as such to preserve the continuity of the company, to enhance efficiency and avoid dismissals, which, as we all know and as we all agree, is the worst case scenario. So I would just like to thank you for your presence. Thank you very much for being with us. And here are the dates. Mark your agenda, the dates of the next webinars we organize. We organize one every month on, I would say, trendy subjects. And the next one will be on Uber. And you will be pleased to know that by the end of this week, a new decision by the Commission will be published on the Uber chauffeurs, whether they are salaried workers or self-employed. And I can already tell you that the Commission to regulate the employment status decided that they were to be considered as employees, salaried workers. Nevertheless, the last word has not been said on this subject. It is indeed about the big subject difference between self-employed and salaried workers. That's what we are going to address in our next webinar on the 9th of February. Please register and join us. Have a nice day, stay safe, and keep healthy. Thanks. Bye.